morning. We're here this morning before the Nevada Commission on Judicial Discipline. We're here for two matters. The Honorable Melanie Andress-Tobiasson for case number 2019-090, and the Honorable Amy Chelini, case number 2019-091. Presiding this morning will be the Honorable Mason Simmons. I'm Gary Vause. I'm the chairman. I would like the members of the commission to introduce themselves, starting with Joe Sanford.
Good morning, Joseph Sanford. Joseph Sanford, Commissioner of Carson City.
Bruce Hahn, Attorney Member of Washoe County.
Mason Simons, a judicial member from Elko County.
Thomas Armstrong, judicial member from Carson City.
Stephanie Humphrey, lay member from Carson City.
Karl, Armstrong, attorney member, Clark County.
And I'm a lay member from Clark County, Las Vegas, Nevada. So I'll turn this proceeding over to the Honorable Mason Simmons.
Okay, good morning. My name is Mason Simons. I'm the designated presiding officer today. The time is 8:04 a.m. It's December 16, 2019. We're on the record in the matter of the Honorable Melanie Andress-Tobiasson, case 2019-090, and the Honorable Amy Chelini, case number 2019-091. The Nevada Commission on Judicial Discipline is now in session. We're here in reference to an interim suspension hearing. We do have present here prosecuting officers Thomas C. Bradley and Brian R. Hutchins. We also have present Judge Melanie Andress-Tobiasson, along with her counsel William Terry, and then we also have Judge Amy Chelini, along with counsel Thomas Pitaro, and I believe Michael Maselli, you're also counsel for Ms. Chelini, is that correct?
Yes, that's correct.
Okay. Just a couple of brief administrative issues, and I'll allow us to address any preliminary matters that we need to get into before we allow opening statements and begin the calling of witnesses. There are, I believe, 4 different media organizations that submitted requests to cover the proceedings today. I'll just note for the record that our proceedings are governed by the Nevada Supreme Court rules on electronic coverage of court proceedings. Just to speak a little bit about video recording of the proceedings today. We will not be allowing any live streaming of any video of any court proceedings today. Any video excerpts of the proceeding cannot be posted to any media outlets until the conclusion of both days of the proceeding. And that's the rule that will govern our proceeding today. Just a reminder, during any breaks, we'll take periodic breaks during the proceeding. Just a reminder that there can be no use of any recording devices of any kind, either audio or video recording devices during breaks in the proceeding. This case remains an ongoing investigation. I would just remind the parties of an ongoing obligation pursuant to the Nevada Code of Judicial Conduct Rule 2.16, subsection B, provides that a judge shall not retaliate against a person known to have assisted or cooperated with an investigation of the judge. Are there any preliminary matters that we need to address before we begin opening statements or the calling of witnesses?
Not for us.
Mr. Bradley, do you have anything?
No, sir.
Okay, Mr. Terry.
Thank you very much, Your Honor. And may I refer to you as Your Honor during the course of the proceedings?
That's fine, Mr. Terry.
We have questions in reference to the proposed exhibits. Both the special prosecutors and we have submitted exhibits. But we are not aware of whether or not the commission members have had a chance to review those prior to these proceedings. May I make that inquiry?
I believe all of the exhibits are posted on the secure server that the various commission members have access to. So I believe all of the commission members would have had access to those materials prior to the proceeding.
Here's our concern. A number of the exhibits deal with interviews. It's our position that those interviews are hearsay and that they should not be considered at all unless the witnesses testify. And our concern is that the commission, and we say this respectfully, the commission may have already reviewed all of those interviews. So we're already starting out, as far as the respondents are concerned, in a negative position, because if somebody doesn't testify, the commission has already reviewed each of those interviews and any other additional documents. We're prepared this morning to provide for the first time, even though we have provided those to the special prosecutors, what our exhibits are. So may I again inquire, and I believe Your Honor has answered the question, am I to assume that each of the commission members has already reviewed each of the interviews that were done?
The extent of each individual commissioner's review of the various materials, I guess, is subject to that individual commissioner's involvement with the case. But they've had access to all of the materials, and you can correct me if you have a different interpretation, Mr. Terry, but my understanding, and pursuant to Alverson and other Supreme Court precedent, this is an ongoing investigation. The rules of civil procedure and the formal rules of ethics do not apply to this particular junction. The various interview materials, investigative materials that were relied on by the commission in making a determination that they had the intent to proceed with an interim suspension have been made stamped and are part of the exhibit. All the materials that were relied upon are part of the record. So those materials, whether or not the person is called or not, were materials that may have been relied on by the commission in arriving at a determination, at least initially, subject to this hearing, that an interim suspension may have been warranted. And so those materials are within the record, and I don't know that I agree with your interpretation that those should be struck or something like that, because the person may or may not testify.
Well, it is our position they should be struck and not considered. And we had filed a motion in reference to the issue of being both the terminator of whether or not such a proceeding should occur and being the final adjudicator. That motion was denied, and we accept the panel ruling on that. But it's our interpretation of Alverson that only legally visible evidence should be considered, even at this stage, even though this is a full ongoing investigation. So we take the position that we will object on hearsay grounds to any documents or any information or any type of an opinion that does not have any formal foundation. That would be equally applicable to any of the exhibits. Having raised that issue, our second concern is the time limit. Both Mr. Pitaro and I represent independent judges, but we have attempted we moved to consolidate in an effort to bring this matter to fruition. That certainly was not opposed, and the chair ultimately ruled, and the panel ultimately ruled that consolidation should occur. Mr. Pitaro has a client, I have a client. We've given us 6 hours. That 6 hours includes cross-examination. Again, Mr. Pitaro and I have tried to work out not to step on each other, so to speak, and not to be repetitious in our questioning. But our concern is that 6 hours is simply not going to be sufficient. We have provided the commission with the notice of witnesses. You are aware of that from authorizing the subpoenas that you did authorize. And our concern is that 6 hours is simply not going to be enough time. At a minimum, we want to re-raise that issue if we see it's a problem prior to the second day of these proceedings. I will tell you that we've advised each of our witnesses to appear on Tuesday. We are going to invoke the exclusionary rule, so that way we have no witnesses here other than each of the judges. But if we could be allowed to re-raise that issue at a later point in time, I would appreciate it. In Alverson, the commission allowed the special prosecutor additional time. I didn't think that was a big problem. In Alverson, yet it was raised as an appellate issue, and the Supreme Court didn't feel it was a major problem either. So we would hope that the same courtesy would be extended to the respondents if we need it.
We'll do our very best to accommodate concerns as to time. There is a specific, the order provides 6 hours of consolidated time for each side to present their testimony and evidence. We'll do our best to recognize that we're dealing with limited availability of facilities and also people that are traveling back to various locations and travel arrangements that have to be met as well. So we'll do our best that we can. Mr. Pitaro, do you have something else?
Just one thing, I would ask that, as I think is obvious, any objection Mr. Terry makes would include, on behalf of Judge Chelini and vice versa, so we don't both be covering up at the same time.
Is that okay, Mr. Chair?
Absolutely.
Okay.
And there's one other thing, there's subpoena for Melody Long. She was a human resource individual. I spoke with Mr. Bradley, and he said we didn't need to go out and re-subpoena her. I told him that we were going to be a witness. I don't know if in fact they did in fact subpoena her. She was listed as one of the ones that gets subpoenas on. So I may need a subpoena issued if she doesn't, if she doesn't come. So I understand that we're relying upon his subpoena based on conversation, but I'm not sure if she was or wasn't.
Okay, well, if that becomes an issue, speak with Mr. Dyla about the issuance of the subpoena if that needs to be addressed. Mr. Terry, do you have something
I
else?
could probably add something to that. I left instructions with my staff to get a hold of Ms. Long to contact her, to let her know that she would be needed for tomorrow. I understand that the special prosecutor had issued a subpoena for her. We did not request a subpoena for her in light of the fact that the special prosecutor had already issued a subpoena for her. But it's our expectation she will be here.
And I just been informed by Ms. Hutchins that they in fact did subpoena her.
Okay, thank you. Any other preliminary matters we need to address before we move on?
I do have one question.
Sure.
Procedure. Who's keeping track of time?
Where's our timekeeper?
We have a timekeeper?
So we have a timekeeper back here in the back, and periodically, if you would like us to give you an update of how much time you have left, we can certainly have her give you an update.
Good, thank you.
Okay. Okay. At this point, we're going to move on then to opening statements before I have the parties. I'll actually do this. Let's just have the parties name their various witnesses first, and then I'll have the parties move on to opening statements. So let's have Mr. Bradley, Mr. Hutchins, if you want to name your witnesses today.
Good morning. We're going to have David Denson, Maggie Tucker, Kim Campbell.
Also, before me, if you would. Then your third one.
Get right at that. Sorry. Kim Campbell. Elizabeth Code. Nicole Brewer.
Can you spell that last name for me?
B-R-E-E-R.
Any other witnesses to name for the prosecution?
I'm sorry.
Any other witnesses to name?
No.
Okay. If I can have respondents name their witnesses as well for us.
The witnesses that we are expected to call up as follows: Susan Bachman, judge; Karen Aaron, judge.
Take it slow for me if you would.
Sure, I'm sorry. Bachman, B-A-U-C-U-N;
Okay.
Bennett, B-E-N-N-E-T-T -Aaron, H-A-R-O-N; Judge Ann Zimmerman, Z-I-M-M-E-R-M-A-N; Judge Harmony Letitia, L-E-T-I-Z-I-A; Holly, and I'll spell the last name, S-T-O-B-E-R-S-K-I. She is a pro tem judge that sits on the bench periodically. Melanie Long, L-O-N-G, Giselle Hernandez, H-E-R-N-A-N-D-E-Z, Jose Espinoza, E-S-P-I-N-O-Z-A, Belinda Harris, H-A-R-R-I-S, Melissa Navarro, N-A-V-A-R-R-O, Marisha Proctor, P-R-O-C-T-O-R, and Socorro, S-O-C-O-R-R-O, Carrera, C-A-R-R-E-R-A. We have other witnesses that we subpoenaed, but those are the ones that we believe can provide will be called.
Okay, thank you.
And as long as my colleague said. We did subpoena Joseph Bonaventure. It's questionable whether we'll call him.
Okay.
Judge.
Does either party wish to invoke the rule of exclusion as to the witness?
Yes, Your Honor.
Okay. Are there any witnesses present here in the hearing room? No one was named. So I'm going to leave it to prosecuting counsel and responding counsel to admonish any of the witnesses as to the rule of exclusion when they arrive. Doesn't look like any of them are actually present at the moment. Mr. Brown.
May I inquire through Your Honor, if the respondents intend to testify? They were not listed.
Mr. Terry and Mr. Pitaro.
The answer to that one is simple. We recognize that we have a duty to cooperate. We did not name them as witnesses, but obviously, if the special prosecutor calls them, they call them. If we call them, then obviously that would be the situation. It's necessary for me to place both of their names as potential witnesses. I do so at this point in time.
Thank you. Any doubt on that, Mr. Pitaro?
No, Your Honor.
Okay. Anything else before we move on to opening statements?
Sitting judges get contempt running all the time.
I find you in contempt. I am going to incarcerate you.
Any statement that you make is under penalty of perjury.
No, that's not how it works.
We will take this case under submission.
That would require proof by very significant evidence.
You both did a good job bringing all this to my attention.
I'm going to make a record about you in a minute. You need to sit down and be quiet.
Okay, we'll start with opening statements from the prosecution. Please proceed.
Thank you, Your Honor. Members of the commission, as you know, my name is Brian Hutchins. Hired as special counsel for this matter. And I want to start first with a case timeline, just so we're all on the same page as to when things have happened as far as these cases. I want to let you know when this all started and how we got to where we are. First of all, on March 18th of this year, the commission received from one of our witnesses, named is Maggie Tucker, a letter with regard to these respondent judges. You'll hear about that. On May 31st of this year, the Commission authorized the Executive Director to file a complaint, which was done. The Commission asked on June 11th for an investigation. On March 26th, the clerk of the court, the administrator, Kim Campley, was terminated without warning by Judge Bachman and was escorted out of the building. The Commission investigator began contacting witnesses for interviews from June 17th to June 26th. These are all noted at the beginning of their interviews as to when they were first contacted. On July 3rd, the division administrators Dave Denson and Elizabeth Cota were terminated without warning by Chief Justice Blocker, and they were escorted out of the building as well. The interviews by the investigator were held from June 28th to July 12th, and on August 27th and 28th with respondents. The investigator's report was filed with the Commission on September 30th after extensive interviews. This Commission determined on October 18th to issue the interim suspension, or their intent to issue that suspension. So this is a timeline I think that we should keep in mind as we move along today. I do want to recognize that the burden is noted in NRS 1.4675, so paragraph 4, which authorizes the Commission during any stage of a disciplinary proceeding to suspend a judge from the exercise of office with salary pending the final disposition of the complaint if the Commission determines by a preponderance of the evidence that the judge poses a substantial threat of serious harm to the public or to the administration of justice. And that's what we will be working with today. We believe a preponderance of the evidence will demonstrate that these judges, the respondents, Judges Andress-Tobiasson and Judge Chelini, will meet that standard. With regard to the evidence, as you've now heard, we will not call all of the witnesses that have been interviewed and that we might have access to. We don't believe we have the time. We know the Commission has already had the benefit of the transcript of the interviews, along with the investigative reports, which should be relied on at this stage. I want to give the most pertinent and provide the best flavor of the kind of case there is involving these judges with regard to the issue of suspension and not any and all charges which may ultimately be filed, because formal charges have not yet been filed, as this Commission knows. As such, I'm also not asking the witnesses about everything they know about the entire situation. The investigative interviews, I recognize, were a little jumbled as to the topics discussed. We hope to have a little more structure to some of those witnesses. You'll hear from the previous administrator for the court, Kim Campley, whose last name now is Crofts, C-R-O-F-T-S. She was the administrator from 2015 until her abrupt termination in March of 2019. She'll tell you the problems that there were with regard to trying to assign clerks to the respondents' courtrooms and try to move clerks from their courtrooms to others. She'll let you know how these two judges behaved inappropriately in many situations. The two previous criminal division administrators for the court, Dave Denson and Elizabeth Cota, who were terminated on July 3rd of this year, they'll testify. They oversaw the hiring, training, assignment, and discipline of courtroom and other clerks. A current supervisor in the criminal division of the court, Maggie Tucker, continues to supervise clerks in that division, will be called. She's also the one who sent a letter to the Commission in March of 2019, which is attached to the Executive Director's complaint in each case filed on May 31st. You'll hear from a former executive assistant to the court, former executive assistant to Kim Campley, Nicole Greer, and she was involved in the daily work of the court administration, interacting with these responding judges and described many incidents. A couple of points I'd like to make. Unless this Commission decides otherwise, this is an ongoing investigation, as the presiding judge has now stated of the claims against these judges. We expect that unless there's intimidation or obstruction, additional witnesses will be located or will come forward in the future. We believe many more witnesses will be interviewed. We believe many more documents will be obtained. As a matter of fact, we have sent out subpoenas for personnel records, which the Court, Human Resources Division, and County have been very stingy with, frankly. And we've sent subpoenas for such records as emails and other documents. Unfortunately, we do not have those records back at this time. Because it is an ongoing investigation, we have not made conclusions yet as to exactly what happened to cause the personnel upheaval in the clerk's office this year, although we have some good ideas. Also, we've not determined that we have discovered all the improper actions of these judges fitting within the charges so far. We continue to receive documents. We are not using all of these documents here that come in. It's very difficult to keep track of what we've got, but at this point, we haven't provided everything that has come in just haphazardly to the other side as we get them, because it is an ongoing investigation. In any event, a preponderance of the evidence will show that these judges pose a substantial threat of serious harm to the public or to the administration of justice, as stated in the Commission's determination in each case on October 18. The evidence will show that each engaged in a pattern of abusive, intimidating, harassing, threatening, demeaning, condescending, offensive, and unprofessional behavior towards the court administrators and employees and created a hostile work environment. That's the first statement in the Commission's document noticing intent to suspend. The second was each engaged in a pattern of abusing the prestige of judicial office and interfering in human resource matters, including with respect to the assignment of court clerks and disciplinary investigations and actions. Additionally, each engaged in a pattern of not cooperating with court officials in the administration of court business and not performing administrative duties competently. And finally, each of their inappropriate behaviors consists of a pattern of recurring misconduct taking place over several years. At this point, the behavior appears to be off the bench, but still, it's very important for the administration of justice. Although the charges regarding suspension assert that the conduct was in the past, you will see the evidence demonstrates an ongoing pattern of behavior.
Thank you, Mr. Hutchins. Respondents, counsel. Opening statement.
Good morning, Commissioner. I'd like to address myself first to some of the comments made by my worthy colleague. These two judges, and since I speak for Judge Tobiasson, I will also speak to a certain degree for Judge Chelini, are only interested in one thing, and that's how their court functions. Not one piece of evidence that you are going to hear today from the special prosecutor has any negativism in it in reference to what their court actions were. Nothing that deals with competency issues, nothing that deals with the way they treat their own staff. The concern of both of these judges is that they want an efficient court run. So I'll give you an example of part of what we expect the testimony to be today. Judge Tobiasson had a clerk in her court, a backup clerk by the name of Jose. He's one of our witnesses. He had been with her for a period of 5 years. Judge Tobiasson runs the domestic violence court. It's a very, very busy court. It runs approximately 150 people a day. That includes arraignments, status checks, setting of preliminary hearings, the conducting of misdemeanor trials, the conducting of preliminary hearings. That is her function. That is why she was elected. She has a major concern as to what people are clerking in her court. And that is a justifiable concern, because if a clerk makes a mistake, it has severe consequences. A person remains in custody because of a clerical error. The wrong wrong type of monitoring is set down in the minutes. These clerks that will testify for you, including Jose and Ms. Sikora and Judge Chelini's clerks, will tell you why it's so critical that they have their function. And no offense, not every potential clerk can come in and do that work. So you have to place yourself in Judge Tobiasson's position. You're driving to work one day and you get an email or a text that the clerk that you've had in your courtroom for 5 years is being taken out of your courtroom. No courtesy extended to that judge by advising her prior to and giving her an opportunity to be heard. She is not happy about that because this man works hard for the court system and he does a good job. He wouldn't be in there for 5 years. And as a result, they do not move Jose. And you're going to hear that this is part of this intimidation, et cetera, et cetera. So what we're going to ask you at the conclusion of the proceedings is put yourself in Judge Tobiasson or Judge Chelini's position. And think of how you would handle it if a clerk that you relied upon in an excessive caliber was suddenly being moved and you didn't know who you were getting or the person that you knew you were getting, you knew was not going to function well in that court. Ultimately, this judge is responsible to you, but she's also responsible to the administration of justice. No evidence will come before you in reference to disputes with her own staff. No evidence will come before you in reference to what occurred in a courtroom that should cause this commission any concern. Whether it's her attire, she always wears a robe as is expected from a judge, or whether it's language. You will hear no evidence of abusive language being used in a court, either against the DA or a public defender or anybody else. The whole purpose of this hearing is to determine whether or not she poses a substantial threat of serious harm to the public or the administration of justice. To the public has to be considered first, because that is her primary responsibility. This is a judge that was rated in the upper 74th percentile for retention. Judge Chelini, 92% for retention. So that gives you a fairly good idea of what the lawyers that appear before this think about that. We would hope that you would withhold any decision-making processes until you've heard from the respondents' witnesses. I must say that one additional comment is necessary as a result of my colleagues' address to the Commission, and that is the fact that this is an ongoing investigation. Our subpoenas were given. We had filed an original motion for blank subpoenas almost in the inception of the case. That was denied, and we thereafter requested specific subpoenas. That was granted, and I believe it was last Monday that we received those authorizations. Nobody can respond to a subpoena they can take within a week. So I suggest to you that while this is still an ongoing investigation, you have to take into consideration that we have not gotten all the documentation that we have wanted either, that we believe would show further respondents' positions and a potential defense. So it's a two-edged sword in this case. While the special prosecutor says they're still seeking information, none of our subpoena data statements were granted. Or they were granted, but they couldn't be effectuated because typically you need 2 weeks to respond to a subpoena data statement. In reference to the witnesses that the special prosecutor will call, we will have our opportunity to cross-examine them. I would ask you to take that into consideration. These two women do not pose a serious threat to either the public or the administration of justice, merely because they both echo a sentiment that says, we want certain people in our court that are competent Isn't that really what these judges are elected to do? To be competent and to have competent staff? Thank you.
Thank you, Mr. Terry. Mr. Pitaro, do you have something else?
Yes, if I could. And I agree and adopt what Mr. Terry said concerning these areas. I represent Judge Amy Chelini. As most of you know, that every year the Review Journal and UNLV put together a rating of the judges. And it was just published the last few weeks. We had it as an exhibit. Judge Chelini is the highest rated judge in the Las Vegas Justice Court. The highest rated judge in the Las Vegas Justice Court of the 15 judges that are there, and that's the courtroom we're talking about. In addition, she is rated higher than all the district court judges, the civil judges who practice downtown at the Regional Justice Center. She is rated higher than the appellate judges, and she's rated higher than the Supreme Court justices. So what the community has done, and that community being the people who are in that court on a daily basis, prosecutors and defense attorneys, they have rated Judge Chelini the highest rated woman in that circuit. So when we talk about the idea of she poses a threat to the administration of justice, that is surely belied by the people that are there on a daily basis. And I think that is a very important thing. Judge Tobiasson has always rated high during these and her terms there. So the point that I'm making is, when you look at this and you take that step back and say, okay, well, how was she looked upon in the community that she is the judge? And in that community she is looked on as the highest woman. Judge Tobiasson has always been high also. But I was fortunate to be representing Judge Chelini when this report came up. And we haven't given it, but it's been in the newspapers for days concerning that. And so with a judge like that to turn and say that she is a danger to the judiciary, sufficient that she must be removed from the bench pending being literally charged with something, to us is not something that is there in the record or what happened, and we got the tangible point with this survey. So I wondered, why are we here? The complainant is this Maggie Tucker. She's the one who wrote the complaint. She was anonymous, and then she came forward, etc. You're going to find the gist of the complaints by certain, I believe not all, certain people, and every one of them will be ones that the prosecution of the state calls. What they want you to do, and this is in the original thing that we sent out, and this is Maggie Tucker. My question is, why court administration is at the mercy of judges? She goes on that the judges shouldn't have the court administrator work under her. That's her complaint. Her complaint is that she does something, it goes through a process, and it is reviewed. And she doesn't want that review. She doesn't want the judges who are running the courtroom, the judges who are elected, the judges whose reputation is on the line, the judges who have to treat all the litigants fairly and impartially and efficiently. Her friend is the court administrator, is under the auspices of the chief judge and the judges. Now that's not something, that's what she wants you to solve. That's what she is complaining about. I don't like it that the judges have input. But in fact, one of the things that she said in her statement, it'll come out, she made a statement like, We don't want to give judges clerks who they like. Now, take a step back and think of that. The function of the clerk and the judge, they have to work in harmony in that courtroom together to do what they're charged to do. They are the face of justice. And Judge Chelini got her high marks not just because of her, because her courtroom is run very efficiently. And yet Maggie Tucker's objections come down, really, to I don't like it that the court administrator overrules me and/or the chief judge makes the final, could make the final rule. That is in there. She called the court administrators puppets. They're puppets of the court. The person who doesn't seem to have any respect for the system is one who wants to change it. That's not your function, that's not my function. That's a function of the legislature. That's the way this courtroom is set up and has been set up. And a lot is made, and I want to thread this idea that there's a blacklist. There is no blacklist. Years ago, years before Judge Chelini was ever there, as a matter of fact, one of the exhibits of the status company put in as a letter from Judge Bonaventure concerning the clerk and parties, was well before she was ever even a judge. She was elected in 16 and took office at the beginning of 17. What we had is a situation of compatibility and consistency. And that is if a clerk works there and is doing a good job in that courtroom, of course the judge wants that person to stay there because that person's a known quantity. And Marisha Proctor is a known quantity. She is, in fact, an excellent clerk. And that's why Judge Chelini is always trying to help her because she helps Judge Chelini. I think one of the things that it's been missed by these people is that everyone's there. You're not there because supervisor independent. Everything comes down to how do we administer justice in the courtroom by the court. Everyone in who we're talking about that will be called and is in that system, they're support staff. They can either do a good job or a bad job. But if it's a bad job, it gets reflected in the administration of justice by the judges whose name is on the placket, who are the face of the courtroom. And as Mr. Terry said, not one of these items, not one of these situations deals with in the courtroom. Because it can't. I got the best judge in the system. So it's going to be pretty hard to come in and say what a terrible job she's doing in the courtroom. That is the essence. You're not here to change the system. Whether the system's good or bad, that's someone else's decision. But that is the way the system is. And that, as I was reading Maggie Tucker's saying, that's what it is. How dare these judges overrule me if I do something? I know what I want to do, and I want to do it. Never considering that it is the efficiency of the court. The staff helps them. They're not there to help staff. It's the other way around. And we have the system where the chief judge is with the court administrator, the court administrator goes down to assistant and then the supervisors. And what this is, it's complaints that things did or didn't happen that they particularly wanted because there may have been what they call interference or maybe overruled. They now have come up with its harassment, bullying, and whatever else pejorative terms that they want to use. So, well, the evidence with Judge Chelini and with Judge Tobiasson, because the witnesses basically are saying, it all comes down to who is in charge of the court. Under the structure we have, the Chief Justice, the Chief Judge and Justice Court is in charge. With input with the judges, the other 14, through the administrator down. So the person at the bottom of the chain is the one who is complaining that her decisions aren't being follow in all cases. And you will find out when you're done, personalities may come into it, and they do in any sort of situation, and you try to resolve, good administrator tries to resolve a conflict among people. And these are fast-moving courts. Justice Court with Judge Tobiasson and Judge Chelini, those are courts that move. Some courts can do it, some can't. But it's a moving court. It's a very, very fast court. I'm always amazed when I go to federal court of how slow it is, how long it takes to get through one case. Over in Justice Court, we get through 50 cases. The evidence is going to show that Amy Chelini is no more a danger to any than you people. Amy Chelini is an asset. Judge Tobiasson is an asset. They're assets to the court system. They're assets to this community. And they are the face of this community. And that's why they scored so well on these things. And we'll bring in the evidence to do it. But I want you to think of, think of what it is at the essence here. It's they want to change the system because they don't like the court administrator takes direction from the chief judge. And that's what they want to tear down. And that's what you're going to be ended with all the witnesses who have come. And I'd like to point out, there is no conspiracy against clerks. Judge Chelini will testify, other people will testify, there's no conspiracy. The idea that because Denson and Carter got let go by Judge Bockham, that somehow that is on Amy or Melanie. They have no input into that decision. They had no input, and yet that is the way the state tried to present it in the
chronology.
And put it that way, but I want to give you another one. Amy Chelini calls Denson with another judge and says he's the acting, at this time he is the acting court administrator because Kim Kaplan, the court administrator, decided to take leave. She's not there. He's the acting administrator. And so who do the judges go to? They go to this person that makes the decisions within the, and they ask Denson to move Maggie Tucker so she is not supervising Mauricia Proctor, the clerk. They ask. What happens? He says no. It's tough to be bullying someone when the person says no. Now, when the new court administrator came in and found that there was also a complaint by Judge Chelini's clerk against this Maggie Tucker, then a decision was made to move Marisa to a different supervisor. But it wasn't just her, it was, they shifted. One supervisor is like 1 through 15 courts, and then 8 through 15 goes to another one, and they just switched. There was no retaliation, no loss and pay, no nothing. They're doing the same job. That is one of the things. But think of this, the day Amy Chelini talks to Denson about it, the next day, or at the same time, is when Maggie Tucker, after that, is writing her complaint to you folks. Same time. And complaining about Mauricia, and so the next day, the chief gets a coach and counseling one, and we'll go into what those things mean. But that all happens within 2 days. I mean, that is an interesting situation. Now, everyone says, well, that one didn't have anything to do with the other. Well, that may be. Just like one had nothing to do with the other with the termination of at-will employees. And that's what Kaplan was, that's what Denson was, that was Carl, was their at-will employees. who literally work under the pleasure of the Chief Judge of Las Vegas Justice Court. That's the system. I know Maggie Pepper doesn't like it, but still that's the system. I know Tim Kaplan and Elizabeth Carter and Dave Denson didn't like it. They're Admiral employees and they're no longer there. But that doesn't make Amy and Melanie bad judges. But they don't show that what they're fighting for, our clerks will do a good job. Not like fighting for clerks to do a bad job. They fight for clerks to do a good job. And they have exceptionally well-run courtrooms as reflected in Amy's top rating and Melanie in the top half. So that's what I'd ask you guys to be looking at, and the ladies to be looking at as we go through this. That is it. Thank you.
Thank you, Mr. Pitaro. Just a quick reminder before we move on to the prosecution's case in chief, everyone in the hearing room, please remember to please silence your cell phones so they don't go off and disrupt our proceeding here today. Okay, we're going to move on then to the prosecution's case in chief. Who will be our first witness?
David Denson.
David Denson, if you'll retrieve him from the lobby.
Your Honor, do we have an exhibit book that would be available for?
I think there's one sitting right over there.
Each of the witnesses.
I believe so. If you want to just leave that one there, they can make reference to it as necessary.
Perhaps this would be a good time, Your Honor, for the respondents' exhibits to be submitted likewise. We would have your permission to submit our exhibits to you.
Be
There are
fine.
both the original and then there was a supplement that was done. We purposely not given those to the commission before this time for reasons I've already articulated.
Okay, give me one moment, we'll get into that here. Mr. Denson, if you please face me, raise your right hand and be sworn. Do you solemnly swear any testimony you provide to this panel is the truth, the whole truth, and nothing but the truth, so help you God? I do. Go ahead and have a seat there if you would. If you'll make sure there's a little button there on that microphone. If you push the button, it'll turn that light green. If you'll slide that microphone up close to you so everyone can hear you, okay? So you'll state your full name and spell your first and last name for the record, please.
David Denson, D-E-N-S-O-N.
So going back to Mr. Terry for a moment on the issue of the exhibits, Mr. Terry, do you want to continue with that?
May I do that?
Yes.
And may I move for their admission?
That would be fine. This is Carter, is that right?
I'm sure hands.
This is street hands.
You need to adjust.
I'll just remind the various attorneys, we obviously have people here in the gallery. Please, with your questioning the witness, if you can try to, as much as possible, speak in the microphone so people can hear you okay. Okay, go ahead, Mr. Hutchins. Question for us.
Thank you. Good morning, Mr. Denson. Good morning. Would you tell us what your position was with the Justice Court?
Yes, I was a court division administrator.
Okay, let's talk a little bit about your background before we get into the specifics of that, if you will. Can you give the commission an idea of what your education was?
Sure. I'm retired Air Force 25 years. First 10 years I was a logistician. The last 15 years I was a paralegal. The last 5 years I was a senior paralegal manager within the United States Air Force, responsible for the education, training, and discipline of 200 to 300 paralegals and attorneys.
When did you become an employee of the Las Vegas Justice Court?
In February 2014.
Can you tell the commission how that came about?
Yes, they had an opening, I believe it was around January. I applied for the position because I knew I was going to retire. I came down to Las Vegas from St. Louis, where I was stationed, and had an interview with 2 judges, and was later on hired.
And what were you hired for? What position were you placed in?
I was placed in Court Division Administrator for the Civil Division when I first started.
How long were you in that position?
3 years.
So that would have ended what year?
Around 2017, 2018.
And then what did you do?
From there, my supervisor moved me to the Criminal Division where I was in charge of the courtroom clerks.
And generally, what does that position entail?
Almost the same as what I was doing in the Air Force. You know, it's the education, training, discipline of the employees, as well as implementing new policies and procedures that the judges, chief judge, puts forward that they want for the court. So we're responsible for putting that into action.
Did you have performance reviews or reviews of your performance over the years?
Yes, I have.
And how often did you receive those?
They were supposed to be annually.
And did you get those at some point each year?
Yes, I did.
And can you generally tell the commission how the result of those performance reviews?
Nothing but positive results in every one of the reviews, no markdowns, several outstanding comments from my supervisor, which the first 3 were Kim Camlin, and the last one was Susan Backham.
And Susan Backham is who?
The chief judge in the Las Vegas Justice Court.
And who hired you originally?
The original court administrator was Ladina Gamble. I'm not so sure that she hired me, but she was my first supervisor.
And what do your reviews, let's talk specifically about your last review. Do you recall when you received your last review? You indicated it was from Chief Judge Backham. Do you remember when that was?
I believe it was around March of 2019. Could have been the first week of March in 2019.
And can you tell the commission what kinds of areas that review covered?
Yes, the review covered some of the programs that the court started. The initial appearance court was one of the big courts, so that was one of the big themes to that report.
I'd like you to take a look at the exhibit book in front of you, the large one. And it's entitled the Prosecuting Officers Hearing Exhibits on the front. And these are date stamped consecutively numbered pages. If you take a look toward the back, unfortunately we're going to the back. If you would look beginning at page 1054.
I'm there.
And can you tell the commission what that document is?
This was my appraisal signed by Chief Judge Susan Backham on March 28th, 2019.
And what are the documents after that document? You'll see some others. They look like similar documents, say beginning on page 1057.
It's my subsequent appraisals that were given to me by my supervisor at that time, which would have been Kim Camlin. This is 2018, and then subsequently.
So those were the reviews prior to the one Judge Backham gave you?
That is correct.
Okay. And were there any negative comments in any of those?
No, there were not.
Who prepared the reviews that were eventually signed by you and Kim Camlin?
Kim did all the preparation, put everything together for those performance reports.
And how about the one signed by Chief Judge Backham?
The one that was signed by Chief Judge Backham is one that I put together and gave to her probably probably around February or March, so that she could sign it and give it to me and we can move forward.
And why the difference in the procedure there? Prior were prepared by Ms. Campling, and this one you provided to the Chief Judge.
Well, part of it was Ms. Campling was out. She was out on FMLA, which is family leave. And I was in charge of the office of the department at that time, about 30 days. So Chief Judge Bachman would have been my supervisor at that time. She would have been the one to sign for the court administrator.
Did the Chief Judge Bachman have an opportunity to review and could have altered the document you provided to him?
Oh, sure, yes.
Was there any discussion with her about that review?
No.
During your tenure as an employee of the Justice Court, did you receive any awards?
Yes. In 2015, I was the Employee of the Year. Also, I believe it was 2015 or 2016, I was the Employee of the Month, a couple of different occasions.
Can you look at documents on pages 1052, 1053, and tell the Commission what those documents are?
$1,052 is the Employee of the Year for 2015, and page 1053 is Employee of the Month for October of 2015.
Can you tell the Commission who signed those?
Those were signed by, at that point in time, Chief Judge Joe Bonaventure.
Did you have a hand in determining who the Employee of the Month or the Employee of the Year was?
No, I did not.
After Ms. Campling was terminated, what was your status?
I just went back to, it was kind of in limbo. She was terminated, I can't even remember the day, probably maybe a couple days later. They designated an interim court administrator, which was Grizel Hernandez, and I went back to my previous job, which was court division administrator for the criminal division.
If I represented to you that Ms. Campling was terminated in late March, would that sound correct?
That would sound correct.
And when were you terminated?
July 3rd
of this year?
Of 2019.
And how did that come about?
I was up at a meeting dealing with some of the judges about some of the things that are going on in the criminal division, just regular topics of the meeting. Came down from the meeting, I was invited to go to the HR department's office, and at that time, it was Melanie Long, who was our HR director. She handed me a piece of paper and said I was no longer required to work there, and I was escorted out of the building.
And what was that piece of paper you were given?
It was basically a termination notice from Judge Bachman, signed by Judge Bachman.
During your tenure with the court, did you become familiar with Justices of the Peace, Andress-Tobiasson and Chelini?
Yes, I did.
And do you see them here today?
Yes, I did.
And can you describe generally for the Commission how much you interacted with them over the time you were at the Justice Court?
Not often. There was just a few occasions where I interacted with either one of them.
I'd like you to describe for the Commission generally the organization of the Justice Court, especially with regard to the court clerk divisions for which you were responsible. If you would do that, please.
Okay. So the administration side of the court is, we have a court administrator who's basically in charge of the whole court, including the employees, which I think in the Justice Court there were 300 employees. Below that person, there I think are maybe 6 department administrators or court division administrators. They're in charge of the different divisions, which is criminal division, record division, pretrial division, finance division. There's a couple other divisions I'm probably escaping, traffic division. So from there, I was one of the division administrators in charge of the criminal division and in charge of basically the courtroom clerks, which include the clerks and the backup clerks that go into the courtroom.
Okay, let's get down a little more specific to the criminal division. Is that the name of the division, the criminal division?
Yeah, I think at that time it was called the Criminal Division.
And describe that for the commission a little more specific with regard to how many maybe supervisors you might have, what your title is.
Sure. As the Court Division Administrator, there's one. I had 2 supervisors and 1 training supervisors. The supervisors were the regular supervisors were in charge of the regular court staff. We divided it up by departments. 1 through 8 was one supervisor. 8 through 9 through 15 was the other supervisor. I had a training supervisor who was in charge of all training. So when somebody was hired within the department, they would fall underneath, and his name was Will Jimenez. They would fall underneath him so he could train them to go into the courtroom.
And who were the other 2 supervisors?
Jennifer Adair and Maggie Tucker.
Jennifer Adair, Maggie Tucker. Thank you.
Yes.
I'd like you to take a look at the document number 67 of Exhibit 1 of that large book. Now, my version of this document is a little bit small, it's very difficult to read. Are you familiar with that document? And if so, can you describe a little bit of it to the commission?
I am familiar with it. It's the organizational chart of the Las Vegas Justice Court. Kind of how I was talking about before, you have the chief judge, then you have the deputy clerk or the court administrator. Below that were all the different court division administrators. And on here were the division administrators for pretrial, criminal. It's kind of hard to read. Some of these traffic, obviously civil, finance, IT, and I believe the last one was court education.
All right, let's discuss a little bit more of the court clerks themselves. Can you give an idea to the commission of the number of clerks we're talking about for the Justice Court, the types of clerks you've got?
Sure. We had a total of about 40 clerks. That includes clerks and backup clerks. The difference is the clerks are higher paying, for one, but they are mostly responsible for in-court actions of the judges and inputting information into the case management system as the judge dictates per case. So we have 1 per department for each one of those, and for backup clerks we tried to have 2 per department, and so each department, the goal was to have 3. I don't think while I was there we ever had 3 clerks per department because of just openings, and it just never fell out correctly.
Now, you mentioned you had, I'd say, something like 40 clerks. Was that all the clerks there were in the entire clerk's office?
No. Civil division had, my guess is they probably had 6 or 7 clerks, court clerks, that would handle just the civil department. I believe the traffic department may have had 1 or 2. There was also a couple that were down at the community impact court. So there was clerks kind of scattered all over the courthouse.
Now, when I come into the court and I want to file some documents, I would go to the clerk's office. There's more clerks at that location?
Well, I think the public calls them clerks. We would call them legal office assistants. Those are generally the people at the upfront counter that are helping customers as they're coming in, dropping off documents for the judges.
All right, with respect to the clerks you described in the criminal division, I believe there were about 40 of them. Can you tell the commission who the official hiring authority was for those clerks?
The official hiring authority is the deputy clerk or the court administrator, which would have been Kim Campbell in the administration.
And was that hiring authority responsible for hiring and termination?
Yes.
And can you tell the commission who is charged with doing such things as personnel training, assignment and transfer of duties to those clerks to the courtrooms, the appraisals of job performances, the disciplinary actions, the promotions, the awards, those kinds of things?
That would have been the deputy clerk or the court administrator.
And who was charged with making sure that there was courtroom coverage for each of those departments that we talked about, especially when there are such things as people taking time off of vacation or sick leave, things of that nature?
Yeah, again, that would have been the court administrator.
And what if there's some kind of shortage of clerks? You mentioned sometimes you try to have 2 backups for every department. Maybe you didn't have those. Was there ever a shortage of clerks, and if so, who had to take care of that?
Yes, there was, for different reasons, there were shortages of clerks, whether it be people, just off for family, family vacation time or sick. But oftentimes, if it ever happened like that and we couldn't get enough, we'd have to go to the supervisors and have the supervisors go into the courtrooms and clerk the cases.
Supervisors themselves that you described?
Yes, Jennifer, Maggie, and William Jimenez.
They sometimes would have to do that.
That's correct.
Let me refer you to another document in front of you. If you look at page 54. One is page 54 through 65, and appears to be a similar document from pages 123 to 133. Let me know if you need those numbers again, trying to keep track of those. We'll have you tell the commission what each of those documents is, what they show.
So pages 54 through 65 looks like a breakdown of all the clerks that worked in this department, which would have been Judge Tobiasson's department, from January 12, 2018, and it culminated, this particular list culminates in June 24th of 2019.
Okay, and
this lists all the clerks and the backup clerks and clerks that are in training within those departments. And on page 123.
May I ask a question about here?
Yes, Mr. Chair.
Those documents?
I did not.
Then move to strike as you're saying in the role.
Hutchins.
My response is I'm just getting into the foundation right now, which I'm going to have you explain the origin of these documents and how he came about them and why he's submitting. I just haven't gotten there yet.
Working with a document you didn't prepare, therefore it contains hearsay information upon which he's going to rely and testify. So that's what we reject.
Number one, even if hearsay is inadmissible here, which we don't believe it is, we don't believe it's hearsay here, you'll hear the evidence, he'll say he's responsible for making sure this information is in a certain system that he's going to describe.
I'm going to give you a chance to clear it, Mr. Hutchins. Go ahead.
Thank you. Would you tell the commission the origin of these documents? Where is this information from, what your participation is in that information?
So the origin of this document comes from our case management system, which would be the Odyssey case management system.
Okay. And did you get involved with the Odyssey management system at the time?
Yes, pretty much everybody that works at the court works with the Odyssey case management system.
And what happens? How does this information get to that?
So each day when the clerks go into the courtroom, they assign themselves to the case. It could have happened the day before, but each case has its own record in the case management system that represents who the judge is, who the clerk is, and who the backup clerk is.
And how are clerks, before we get back to finally closing up how this document came about or what it shows, how are clerks, if we use the term assigned, to a specific department, and when are they assigned to a department?
So some of the clerks, it depends. Before I got there, some of the clerks were already assigned to certain departments, but others are assigned later, depending on the circumstances that are involved. There's a high turnover for clerks, so a lot of times clerks will be going in and out of courtrooms. We try to assign them based on the needs of the court. And for example, we have new departments and new judges come in, like to give them more experienced courtroom clerks so they can assist that judge in whatever it is that they need for their first year.
Let me ask you this, are clerks assigned, so you already know in this instance you see on this document, for instance, same name, but is that assigned permanently, that clerk, in a specific location?
I don't know that they're assigned permanently, they're just assigned to that department for that time being. Oftentimes, because we have shortages, we have to move clerks around to different departments. And, you know.
Do you rely on this type of information to know where your clerks are or have been?
We pretty much know ahead of time through the case management system. It's pretty easy, but as the supervisors and administrators, we know where the clerks are.
So these documents are a reliable source of information from the case management system?
Sure, yes.
On our part,
It should reflect a little hesitancy in the witnesses' part.
I'll allow the record to still reflect Mr. Terry. I think given he's reported this reliable, I think the court, the applicant proceed with the
thank you. If you look at the first document that we were talking about, you earlier had said that sometimes supervisors have to sit in as the clerk for the specific department. With this document, each of these documents reflect that?
Yes, they would.
Can you point out an example or two for the commission of where that might be?
You just give me a second.
Sure.
So as an example, on March 15, 2019, Jennifer Adair was in Judge Tobiasson's as a backup clerk, and as I said before, Jennifer Adair was a supervisor, is a supervisor.
Are you on page 63?
I'm sorry, I apologize, I'm on page 63.
Okay.
There's also William Jimenez, just off of this page was March 27, 2019, was the lead clerk in Judge Tobiasson's courtroom as well.
Thank you. We'll come back to this document and these documents. Can you describe to the commission just briefly what the general duties are of a courtroom clerk, especially with regard to, say, the criminal division?
So the general responsibilities are to take down the information that the judges decree on each one of the defendants and input them into our case management system. They work in what we call events, so they write down the events and then they add the events to the case management system, which then reflect what's happening with each one of the cases to the public and different state agencies, such as the most important one would be the jail, the CCDC, so they can get the information over to CCDC, whether they can release somebody or somebody is getting ready to be arrested and should be incarcerated.
Do any of these clerks handle money?
Yes, they're all trained to handle money. It would be the backup clerks most of the time that would handle the money because people need to pay fines, etc., and we do take them in court.
Are these clerks required to be impartial?
Yes, they are.
And describe for the commission, if you would, the training of those clerks.
So if a clerk came in, it's usually an 8 to 9 month training process. Depending on their position as a clerk, they have to learn how to back up clerk, and then they have to learn how to clerk. So they go into different departments. They first start out with William Jimenez, and it's about a 4 to 5 week course where he breaks down the case management system and how it's utilized. Once that's done, then we start moving them into the courtroom. We piggyback them with an experienced clerk or backup clerk so that the training can begin within the actual courtroom. He meets with them weekly to discuss the cases and how they did with the training for that week. And once that's done, which is usually about 8 or 9 weeks, we actually put them in the courtrooms kind of by themselves.
So they don't get into the courtroom for how long?
It's probably a month to 6 weeks.
Okay, is that after the training or the entire training? You said it was about 8 or 9 months.
Yeah, the whole training is about 8 or 9 months, but they don't get into the courtroom until after they've gone to the case management system and are clear to how to use it, because that's the baseline to every clerk. They must know how to use the case management system.
And with regard to assigning the clerks, we talked a little bit about assigning to specific departments, those kinds of things. Is there something when you train the clerks as to where they go in the different departments?
Yeah, so there are different departments that have some different requirements. For example, domestic violence, it's a little bit different from the other departments. They have just a few more things that you have to be aware of as clerks. So that would be one example of trying to prepare people. But the vast majority have not the vast majority, they all have the baseline training to go into any department and to be able to clerk. There are just some that are just a little bit different than others.
And how do you appoint the newly trained clerks or clerks that are being trained with those different aspects?
Again, we try to piggyback them with whatever, with whoever's in those departments, which DV had two departments, domestic violence had two different departments. So we try to piggyback them on with one of the clerks or backup clerks. And then William Jimenez has, that's the department that he came from before he was a trainer. So he has a lot of experience in dealing with domestic violence type cases.
So is it fair to say there's some kind of rotation of these clerks in training?
There is a rotation. We leave them in a courtroom for X period of time and then we move them to a different courtroom. So they have experiences not only with different trainers but different courtrooms.
And in the different courtrooms, are the speeds at which the cases are handled all the same in each of the departments?
No, every judge handles their cases differently in their own time.
Is that part of the training that is supposed to be received by each of the clerks?
It's part of getting them used to, just the different ebb and flow of case management.
Let's talk about during your tenure, what say, if any, the judges generally have in, according to your knowledge, the clerk hiring we talked about, the assignment transfer of duties to different courtrooms, the appraisals of employees, the promotions, the terminations. Can you describe your view to the commission as to what input the judges had in those areas?
It depends. I don't know that the judges had a lot of input into the actual firing because our employees, our courtroom clerks are union employees. So there's a process that we have to go through. You just can't walk up and terminate somebody depending on the circumstance. So we would get feedback from the judges, obviously, if something went wrong, and we as the administration would have to take care of that through some type of a disciplinary action.
Is the level of input consistent among all the judges as to what input they might give in any employee purchase?
It is not. Some judges are more involved than others.
And did the input of any of these judges require the administration during your tenure to keep track of any kind of preferences they might have regarding clerks?
Sure, it's something that we always had to be aware of. I remember, I want to say back in 2015, it was maybe December 2015, when the chief judge at that point in time, Judge Bonaventure, kind of sent out a decree on how we would deal with when I say we, how the judges should deal with the clerks, and how they should deal with administration with those issues.
How would any of these preferences be kept track of by the administration or the management, especially?
There was a spreadsheet that was kept that had each one of the judges and kind of their preferences.
And have you heard the term blacklist?
Yes, I have.
Can you describe for us what a blacklist is?
Well, blacklist in terms of the court was referred to certain clerks were not allowed to go into certain courtrooms. So they were blacklisted from going into courtroom A, B, or C.
Is there another way that the judges might express their preference to keep a clerk? Okay, you just talked about excluding certain clerks. What about if they want to keep certain clerks? Is that information tracked as well?
I believe it was on the same one. There are certain divisions that we knew the clerks wanted to keep those clerks working for them because I assumed they were just comfortable with them.
Now, up to this letter you talked, or this memo you talked about, the chief judge at the end of 2015, let me have you look at page 51 of the exhibits.
I'm there.
Can you describe for the commission what that document is?
It's an email from the chief judge to the Las Vegas Court of Judges. In it,
And the date is December 31,
2015. Yes, I'm sorry about that.
Okay. Were you one of those who received this document?
I am.
Your copy of it on the header there?
Yes, I am. I'm in the CC block.
All right, at this time, can you give us an idea of what led up to this, if you know, the issuance of this memo? Can you tell the background about that?
I was, at this point in time, I wasn't working in the criminal division, but before this, I was actually doing both jobs. So one of the other administrators had left to go to a different position, so I was handling civil and criminal at the same time. At that point in time, we had issues with a couple different judges not wanting certain clerks into their courtroom, which really handcuffed the administration's ability to effectively move our assets, which are employees, around to different departments for the betterment of the court. I was up in that job up until multiple job. I was tag teaming both of those jobs when this started, and then it kind of transferred over to Anna Vasquez, who then took over the criminal department after I did, and then it went on to Elizabeth Coda, and she was hired to be in that position.
At this time, let's talk about the bottom of that page of that document. And of course, we can all read it, but it refers to a statement that effective immediately, in order to assure quality and continuity of services, then the chief judge has instructed court administration to suspend the following accommodations. It points out the demand or request that a clerk or backup clerk be in a particular department, a restriction from a clerk or backup clerk working in a particular department. Is that language the kind of language we're talking about when you were referring to a blacklist?
Yes.
Now, after this memo was issued, are you familiar with whether or not that practice continued?
I wasn't in that department, but I had heard that practice did continue.
Mr. Hutchins?
Did you have, let me clear it up, did you have to deal with the effects of any of those actions?
Yes, I did.
And as you had to deal with the effects of those actions, did you become familiar with the information regarding that?
Yes, I did.
And you dealt with those as the ultimate administrator of that division?
Yes.
Submit.
I'm permitted, go ahead.
I'm sorry, what was that?
I'm going to permit it, go ahead.
Can you describe for us what, if any, difficulties there might be generally for court clerk supervisors and administration if the judges have a say in the personnel matters we discussed?
Well, for one, generally the judges are concerned about their own department, not the court as a whole. So it really restricts our ability as administrators for the court to move people around in the most efficient and best way possible for what we believe for the court. It's very difficult. Many times the morning of, people will call in sick, which happens because people get sick. To be scrambling around to try to figure out what people we can put in each department, it really takes time and effort, and it's really not something that's to the benefit of the court to do something like that. Especially the time and effort that it takes for the administrators to figure it out.
Do you recognize any reasons why a judge might want to have a say as to who the clerks are in their courtroom?
Sure.
And what would those situations be, or what would those reasons be?
I know a couple of different occasions clerks had lied in the department, and I certainly understand, or lied to a judge, and I certainly understand why a judge may not think that's appropriate to have somebody in their department that lies to them.
And based on your experience and background, do you have an opinion as to whether or not the concerns of the judges should override the administration's supervision responsibilities of the clerk?
I don't think it should override. I think it should be taken in consultation.
Did you, as a supervisor, try to take that into consultation?
Of course.
Consult with judges?
Of course.
I want to talk a little bit, first can I offer you some water?
Yes, please.
Yeah, go ahead.
Let's move to a few specifics about judges who might intervene in some clerk personnel matters. Let's talk first about Judge Tobiasson. Can you tell the commission where Judge Tobiasson's courtroom is?
Judge Tobiasson, when I worked there, was on the 8th floor.
And was there a department number?
Department 10.
You recall any situations in which Judge Tobiasson might have had an input in any courtroom clerk personnel matters?
We had there was one specific time we had an issue with the backup clerk that was working in her department.
Let's try and use maybe just a first name, and maybe the documents will show a second, but for some semblance of privacy, I suggest maybe you just use the first name.
Fair enough.
Okay. Are we talking about a certain person?
Yes, the person's name was Jose.
Okay. And what can you tell us about this situation?
Jose was we had received, and when I say we, the supervision, at that time he fell under Magna Carta. We had received several complaints about Jose from women within...
Hearsay. Objection, hearsay.
Mr. Hutchins.
We'll withdraw the objection.
Okay. Go ahead, Mr. Hutchins.
You can continue.
Go ahead.
So, I'm sorry, I forgot where I was. We had a person, a backup clerk named Jose that worked in Department 10. We had received numerous complaints about Jose and the way he acted towards these folks. His actions, his language, his mannerisms, and they all seem to say the same thing about him. So, as leadership within that division, we had to figure out some way of getting Jose back on track and having him focus on what was important, which was the court matters and not upsetting other members, other teammates.
Can you describe for us who these other individuals might be that were upset? I mean, what capacity were they working in?
Different capacities. We had some that were brand new clerks that were working as trainees. I would call them trainees within the department. We had others that came from records department. We had others that came from the jail, all saying something similar. And then we had one last person that came from a totally different department that actually worked in the DD court for a little bit.
How would you come about having knowledge of all these different complaints you said?
Well, there's two different ways. One was from the supervisors of those people, of those victims, I would call them, of this, of the attitude that Jose expressed towards them. The other some of the people would just come straight to us as the supervision.
Would you personally hear from some of those?
Yes.
You mentioned that some were backup clerks. Let me take you back to the documents we already described. First of all, the one that began on page 54. That's the list you described for us as to which clerks were placed in Judge Tobiasson's courtroom. Is that correct?
That's correct.
Now, does this show the commission the individual you're talking about is Jose individual?
Yes, it does.
And what does it describe that? How does it describe that person's past?
As a backup clerk.
Now, you notice on this document there's several times where he is not the only backup clerk throughout. And do you recognize some of those names?
Yes, I do.
Tell the commission why those names are there, what they were doing.
So typically when you see, in this case, Carmen is on a lot of these. She was a backup clerk that was in training within that department.
On page 58, there's a similar type of situation.
Yes, it's a similar type of situation. Monique was in backup training within that department.
And the next 2 pages.
And page 59, Brett was in backup training as well. And on page 60, Brett was in backup training, and then we had Stephanie Velasquez that was clerk training.
Now, would any of these names be recognized by you as having indicated that there was a difficulty with Jose?
Yes.
This document only begins in January of 2018. Is that the beginning then, just with these names that you recall as far as time?
Yes, because before that I wasn't in that department, so I couldn't comment on that.
Now, as a result of these different indications of problems with this individual, can you describe for us what actions you as the administrator and your supervisors took or wanted to take?
Well, the first thing is to sit down, we call them coaching and counseling, and just sit down and talk with the individual and ask them what's going on, had complaints about issue A, B, or C. In Jose's case, we had issues with different people within the organization saying that he wasn't being a very nice teammate to them. And so we talked to him first to try to see if that alleviates the issue.
Did you personally talk with him?
Yes, I personally talked to him with Maggie Tucker.
Was that in the context of a formal disciplinary process?
I wouldn't call it formal. I would call it an informal process to try to divert them before we get into the formal process, which is not something that we want to do.
Can you tell us about how long this went on, as far as you recall?
As far as, for about a year, we've been having some sorts of issues with Jose.
And at the end of that time, what, if anything, did you do with regard to Jose, or did you attempt to do?
Well, we tried to, when I say we, the supervision in that department, which was Jennifer Adair, Maggie Tucker, Will Jimenez, and myself, we tried to come up with a solution to, if at all possible, keep Jose out of trouble again, try to divert him into what we want him to do, which was be a good team player. So the thought process was to see if we could, because of most of the people that he directed his attention to were females, we tried to put him in a different department with another male clerk to see if that maybe would kind of stop his attitude and how he dealt with people.
Now, I noticed that one of the names that we came across in this list was a male name. Was that one of the issues with that male individual in Jose?
Yeah, I mean, it was of sorts. Because he's a trainee, he has a different mindset when he's dealing with, because he's a trainer for trainees, he occasionally has different mindsets. So that's what we were trying to figure out is it a female thing, is it a male thing, is that just him personally, is that just his personality?
Now, all during this process, when you said there's maybe something like a year this was taking place, did you consult with the judge he worked for or in that department all the time, tell her what was going on and what you were doing and not doing?
Well, we didn't really have a lot of what we do. We try to keep private with the employees because it's really nobody else's business but the employees and us as the administrators. So we try to keep that quashed because it's really an administration function.
So was that a no?
I'll ask the witness if it's a yes or no, or if he has to qualify it.
I'll qualify that. We did talk with her on one occasion when we finally came up with a solution to move forward. We did talk with her on that one occasion.
On a solution to move forward. Thank you.
I didn't hear that.
On a solution to move forward.
What do you recall being the first time there might have been some interaction between you and your supervisors and Judge Weiss? Or is there anything that would refresh your memory as to what that was and when that was?
It was in August when we sort of came up with a solution.
What year are we talking about?
We're talking 2018.
Okay.
And when I say we, I'm talking the management team within the criminal division. Excuse me. So during that time, we had decided as a group, as the leadership group, that we would we would give the judges a heads up as to what was going to happen. We had already made the decision to move Jose to a different department. Once that happened, we discussed internally between the supervisors who was going to talk to who. I talked to Judge Letizia, that was one of the different departments that we were going to move Jose to, and Will Jimenez volunteered to talk with Judge Tobiasson about how this case, about moving Jose to a different department.
You indicated that a decision was already made. You hadn't talked to the judge yet?
I had not talked to the judges yet.
Can you explain to the commission why that was? You're making a decision to move, you didn't.
Again, it's an administrative function. We made the move, what was in the best benefit of the court. Additionally, there was issues there are personnel issues that judges shouldn't be involved in.
So now you indicated you're going to the judges. How did you do that? You said Will was to go to approach Judge Tobiasson.
Judge Tobiasson, that's correct.
Another judge.
And I approached Judge Letizia to discuss the issue of the movement.
Okay, can you tell us what you recall happened at that point?
So after I talked with Judge Letizia, we were on board, so we were going to move from
Hearsay.
You want to respond to the objection and a hearsay objection?
I believe it wasn't. He wasn't telling what Judge Letizia said. He said as a result of his discussion with Judge Letizia. Is that right?
My exact words were after discussing with Judge
Please roll on
Letizia.
the objection first here. Mr. Chair, just announce.
He was about to say what the teacher said. That is what I said.
This might be a proper time to find out a determination from the chair as to where we're going with hearsay and whether it's going to be allowed.
Well, as I had mentioned at the onset of the proceeding, my understanding from the case law would seem to suggest that this particular juncture of this proceeding, this is a pending investigation. There is not a formal complaint filed against these judges. My understanding is, pursuant to the case law, that the formal rules of evidence do not apply, nor do the rules of civil procedure apply. So, obviously, we want to make sure that the evidence that is coming in is reliable. But I think the strict adherence to the rules of evidence at this juncture don't apply. My understanding, and I'll let the parties make a record if they disagree, but I think that's the status of the law.
We would make a record if we disagree. We will lodge that objection again, except that we would ask the commission to construe it as continuing the objection.
We'll note your continuing objection for the record, Mr. Terry. Go ahead, Mr. Hutchins.
Mr. Denson, if you can remember where you were, maybe you can continue.
Yes, so after discussing with Judge Letizia that we were going to move Jose down to her department and switch her backup clerk, her name was Rita, up to Judge Tobiasson. I talked with Will Jimenez after the discussion happened. He said he sent a text message to Judge Tobiasson to let her know of the move.
What do you recall happened after that?
Shortly after that, I went on vacation, and I received a text while I was on vacation from Judge Tobiasson indicating that she didn't want the move to happen. I was kind of taken aback because I was on vacation, didn't get phone calls or text messages from the office or much less judges while I was on vacation, so I thought it was kind of weird and intrusive. So I tried to settle the issue down, told her that I wasn't going to make the move until after I got back from vacation, and we would have a discussion after I got back.
How was any of this memorialized, as you recall?
I saved the text messages that she sent me, and I put it in a memorandum.
Let me have you look at a couple of exhibits. One starts at page 44 of Exhibit 1 of the prosecution's exhibit, and one begins at page 100. The first one I mentioned appears to be dated August 21 of 18. The second one appears to be dated August 20th of 2018. Can you tell us, are these the documents that you are discussing?
Yes, the one on page 44 is the memorandum, and subsequently those are the text messages between Judge Tobiasson and myself.
Go ahead and put it in context and tell for the commission us as to how these came in. If you can refer to the documents and explain that point.
So the text messages, obviously, as you can see, they're dated August of 2016, and my memorandum was August 21st. That was actually when I came back from vacation. The text messages indicate that she didn't want didn't want Jose moved. She had an issue with Olivia and Carmen, which, as I told her, we didn't have Olivia working in the court at that point in time, so I'm not sure who she was talking to. She came back and said it was Monique that was the issue, and that they had stirred up a hornet's nest, and she couldn't trust them any longer.
What did you do in response?
I told her that I would wait until we got back. I would tell Maggie, who was the supervisor at that point in time, who was going to implement the move. I would tell her to wait until I got back, and we could have a discussion with Judge Tobiasson and Judge Letizia.
Then when did you write the memo? Was that on August 21st, I take it? That's when it's dated.
That is correct.
Number 44.
That is correct.
What do you recall happened when you got back?
So we set up a meeting with, I set up a meeting with Judge Letizia and Judge Tobiasson, and sat down and had a conversation about what exactly it is that she wanted to do.
You say she?
Judge Tobiasson, I apologize. How she wanted us to proceed. Kind of gave her a rundown of some of the issues that we were experiencing with the complaints that we were getting from other employees within the Las Vegas Justice Court, just to let her know ahead of time, here are the issues that we're coming across as administrators. At the end, I asked her that she didn't like our solution, could she maybe guide me in a solution that she could come up with to alleviate this issue with Jose.
So did that happen?
She never contacted me again after that.
What did you do?
I sent her, or JEA, 2 emails asking for updates and never received anything back.
So as a result, what happened with that backup clerk?
Jose stayed in that department.
Why is that?
So in order not to upset the apple cart, we decided to try to deal with Jose in the best way we possibly could and just kind of manage who was going in and out of the courtroom to deal with him.
Now, take a look, if you would, at the second document we're discussing. I believe it was an email from Judge Tobiasson on page 101. Do all these documents we're talking about appear to be accurate, correct, the ones that you got?
Yes, sir.
And were prepared?
Yes, sir.
On the second one, page 101, have you read through that document recently?
I have.
And is everything what Judge Tobiasson provided in that document accurate?
It is not.
Can you help us out a little bit here and tell us what you don't believe was accurate?
There are a couple different issues in here. She seems to be claiming that I had some type of favoritism with Carmen and Monique. Fact is, the only thing I knew about Carmen was that she was somebody that we recently hired in the office. I had never spoken to Carmen. Monique used to work with me when I was the administrator, and I hired her over in the civil division. That was really the only interaction that we had with Monique. If you give me a second, can I
Sure.
get through this again? Also, she indicates in the first paragraph that I discussed, or we, the leadership team in the criminal division, discussed the movement with Rita Gonzalez and that she was okay with it. The fact is, it wasn't an option. I mean, we may have discussed her moving, but it wasn't whether she was okay or not with it. It was just, we were telling, not asking.
Did you represent to the other judge, Letizia,
I never represented that to Judge Letizia.
On the carryover paragraph in the sentence, there's an indication that Judge Tobiasson said that after speaking with one of the union representatives, and she gave an understanding about complaints. Were you aware that the union representative had been brought into this matter?
I was not aware.
Were you aware that the judge may have talked to the union representative?
Up until this point, I was not aware until she made it clear that she talked to the representative.
Is that something that you, in your opinion, based on your experience, would believe was appropriate for a judge to talk to the union representative?
Typically, the judges wouldn't have a reason to talk to the union representative about clerk issues. They're the ones that the employees that actually work or hired by the judges are not union employees. So, and that would be their JEA and their marshal. So I wouldn't see why a judge would have a reason to get involved in a union case with one of the employees.
During you said you had a meeting. How many meetings do you recall with Judge Tobiasson? Certainly you had one with Judge Tobiasson and Judge Letizia.
Right. That was the only meeting that I had with Judge Tobiasson.
And can you tell us Judge Tobiasson's demeanor during that meeting?
It was standoffish at first because I think she was upset at how this, you could tell by her text messages and the email that she sent that she was upset about how this transpired.
Was she professional in your mind?
Main question, objection.
I'm sorry.
Objection, main question.
I didn't hear what you said. Vague question? Oh, vague.
Just asking for this gentleman's opinion, having described it after any answers.
I'll permit him to answer the question. Go ahead, sir, answer the question.
She can be unprofessional and professional during the meeting.
And when you say professional or unprofessional, especially the latter, what do you mean by that?
Cussing during the session.
Had you heard that before from her?
No.
Let's move to another situation, and we'll talk about Judge Chelini. You said you were familiar with Judge Chelini. Can you tell us where her courtroom was located?
She was on the first floor in the Las Vegas Justice Court.
And what period of time was that? Where was she the last time you recall?
That's where she was. She was on the first floor the last time I remember.
Okay. Do you recall her ever changing floors, going to the 8th floor?
No, she had, her office was actually on the first floor, but she actually heard cases up on the 8th floor. On the later half. At the beginning, she heard them, it was 1-in-1, so her office, and then she had her cases, and then she moved up to the 8th floor,
Okay.
I believe.
What department was she in?
Department 14.
Not to interrupt my colleague, but it would be appropriate for a bathroom break in this.
Sure, we'll take a brief.
My apologies. But since we went from Tobiasson to Chelini, I thought it was a good thing.
No problem. We'll take a brief restroom break.
Thank you. Okay.